Hello, good afternoon, and welcome to our next IP update. This IP update will discuss the liability for enforcing IP rights, so the liability of the IP holder. My name is Kirian Claeyé of Altius at the IP department, and I'm here today with Sofie Thijssen, and we will discuss the liability for enforcing IP rights. This will be the menu for today. First, I'll give you a brief introduction so that everybody is aware of the scene. What are the particular circumstances and issues that IP holders and or defendants can be confronted with? And therefore also what is the relevance of the enforcement directive, which is the second subject which Sofie will present. Also the decision of the CGU in Bayer versus Gideon Richter a couple of years ago, which Sofie will also discuss, and then I will take over again and discuss the CGU's decision in Mylan versus Gilead, as well as a bit more detail on the Belgian story. So let's dive into the subject. The introduction. In terms of IP enforcement, there is a general flow. So you have alleged violation of IP rights. There can first be correspondence, of course, if you want and need to be aware of the alleged defendant's actions and intentions. Of course, if you want it to be a surprise, no correspondence will be held before going to proceedings. But if correspondence does not lead to a positive result, proceedings may and will be necessary. And in this regard, you can have a number of decisions with conflicting outcomes on the validity or prima facie validity of the IP right, but also conflicting outcomes on the infringement or threat of infringement. If you have indications, but you don't have certainty of the infringement or the infringing acts or the infringing product, a saisie contrefaçon is a very useful tool in Belgium. We've had a different seminar in September, also as part of these IP updates on this topic. If you get a saisie and it's granted and you execute it, you can be confronted with potentially third-party opposition and potentially also appeal proceedings, which can lead to different decisions as part and still as in terms of the saisie proceedings, the third-party opposition proceedings, and thus starting from a prima facie validity and prima facie infringement of your IP right. If you have certainty of infringement, you can then go to proceedings on the merits. Perhaps without even going to saisie contrefaçon before. Here again, you can get a first instance decision and a potential also appeal decision, which can be different compared to one another. But if proceedings on the merits are too slow, you have another option of provisional enforcement, and that is PI proceedings. Here again, you can have a first instance and appeal decision where the court will again look at the prima facie validity and prima facie infringement, but not the validity and infringement on the merits. So there are various possible situations where an IP holder first can get relief, provisional relief, saisie relief, but then finally loses the case because the IP right is not held valid or infringed. These situations, I've listed them on the slide which you're now seeing, and the IP holder obtains a PI at first instance, but it is overturned in appeal. Will it be liable? If the IP holder obtains a PI, but the IP right is later held invalid or non-infringed, will it then be liable? If it obtains an injunction at the level of first instance, but that is then overturned in appeal, in proceedings on the merits, in other words, will the IP holder then be liable? Or if the IP holder obtains a saisie, but later on, the IP right is held invalid, or the IP right holder does not follow up with proceedings on the merits, which normally he should do. Will he or she then be liable? And the question mainly in terms of the first and primary question is, what is the liability regime? Because if the defendant does not need to prove a fault by the IP right holder, of course, it will be more easy to obtain damages. So does he need to prove a fault? If so, we talk about fault liability regimes. If he does not need to prove a fault, we talk about strict liability regimes. And the question is, what liability regime will apply, and that is actually the subject of today's presentation for you. There are arguments on both sides, because on the one hand, the IP holder may not benefit from an IP right that is later invalidated. That is what somebody would say if arguing for a strict liability regime. But on the other hand, parties should await and respect IP rights and at least await a final decision or a decision on the merits. So these are arguments advocating for a fault liability regime. And that brings us to the enforcement directive, which Sofie will discuss with you.
I will start by quickly addressing the enforcement directive. And the most relevant articles of the enforcement directive, which brings us some provisions more specifically to specific to the enforcement of IP rights, are Article 9.7 of the enforcement directive and the direct reflection that we find in Article 7.4 of the directive, with Article 9 dealing with provisional measures and Article 7 dealing with the SESI-like measures in the directive described as the measures for preserving evidence. So what do these articles do? So the articles, they provide for three possible situations that lead to the judicial authorities being able to order the applicant to provide the defendant with an appropriate compensation for any damages that they have incurred because of the measures. So the three situations in which this happens are, first of all, the measures are revoked. Second of all, the measures lapse due to an act or omission by the applicant. Or third, it is subsequently found that there has been no infringement or no threat of infringement. So in either of these situations, this leads to the judicial authorities being able to order the applicant to provide the defendant with appropriate compensation. Now, these articles have been implemented into Belgian law. In what way? Well, almost literally. So the only difference that we find in terms of wording, and here we read that the court can order the applicant to provide the defendant appropriate compensation for any damages, instead of saying the court shall have authority to. But what do these provisions mean? As Kirian just stated, this is the question of today. Does that bring us to a fault liability regime, to a strict liability regime, or to potentially a combination of both? And so relevant here are the decision in Bayer versus Gideon Richter, which I will discuss. Kirian will then discuss Milan versus Gilead and the Belgian story. So the first decision, it is a decision that was, it was a question that is referred to the CJEU by the Budapest High Court. So it is a Hungarian decision from 2019. And the factual background is as follows. I will not go into detail, but what is relevant to see here is that in 2011, we see the PI being granted. A little bit later on, we see the PI being overturned. The case then goes back to the first instance court, and the patent is declared invalid. And as a consequence, the defendants in this case, they claim for damages. So a little bit about the Hungarian law to more understand how this case works and the background of this case. So in Hungarian law, there's actually no similar provision to Article 9.7 of the Enforcement Directive. The way that they deal with this situation is by instead using some sort of bonus pater familias assessment in respect of both parties. So the Hungarian law actually says that the defendant, so the one who has been imposed this PI, will not be compensated for their loss in the situation where they did not act as would generally be expected, so as a bonus pater familias, provided that, so this is the second condition, provided that the IP holder did in this situation act as would generally be expected. So this is a situation where we have the alleged infringer not acting as a bonus pater familias. We have the IP holder who does act as would be expected. Now, the question that was then asked it was actually two questions, but they were reformulated by the CJEU. The question that was then asked is the situation that we have just explained, where the party shall not be compensated for losses which he has suffered due to not having acted as may generally be expected, even though the patent has been subsequently found invalid. Well, this situation is precluded by Article 9.7. And the court is very clear, no, this is not the case. So it is important to note that the court says, okay, the situation is okay, but to the extent that the court, so the national court, can take into account all the objective circumstances of the case, including, so for example, the conduct of the parties, and more specifically here, if the applicant has or has not abused those measures. So, of course, the conclusion that we just came to by the court is very specific to the Hungarian law, but the court has touched upon some very interesting topics in its motivation to getting to this conclusion, which I will address here. So, a very interesting first idea is the fact that the court decided that the concept of appropriate compensation in Article 9.7 and also in Article 7.4 must be given an independent and uniform interpretation. So it is not up to the national courts to decide on the scope or the way that this concept is interpreted. And the court also says in that respect that this is in line with TRIPS, because TRIPS allows the member states to go a bit further to provide extra protection, and the court says that this is effectively what the legislator of the EU wanted to do here, namely provide for a high, equivalent, and homogeneous level of IP protection. Further, the fact that the court states that the fact that the conditions of Article 9.7 are satisfied in a specific case, and this is very interesting for the case that Kirian is going to discuss next, that this does not mean that the competent national courts will automatically and in any event be obliged to order the applicant to provide compensation. So it is up to the national courts to assess the specific circumstances of the case and then to decide whether it is appropriate or not for the applicant of the measures to pay a compensation, which is then, as we just discussed, to be appropriate to the defendants. And this is interesting because it almost seems like the court is saying now that a strict liability regime would not be compliant with the enforcement directive. Then further on, the court states, well, Article 9.7 and the compensation that we see in this article, it actually acts as a guarantee to cover the cost and the injury that the defendant has incurred because of an unjustified application for provisional measures. So they are using, they bring forward this benchmark of justified versus unjustified applications for provisional measures in when discussing whether or not this compensation is to be granted. And they give us a little bit of insight into when we can talk about a justified versus unjustified application. So justified being that any delay would cause irreparable harm to the IP holder, and unjustified being if this is not the case, so there is no risk of irreparable harm. And the court goes on to say that in the situation where a defendant markets their products, even though there is a patent application, or even though there's a patent hindering marketing, well, this might prima facie be regarded as objectively indicative of such an irreparable harm, of a risk of such an irreparable harm being the case. And then further on, so as we know in this case, as I explained with the facts, the provisional measures here had been repealed. So the question is also the fact that these provisional measures have repealed, what does that mean? What is the implications thereof? And the court reminds us that, of course, this is one of the conditions that we see in Article 9.7, Article 7.4, for leading to the judicial authorities to have authority to decide on this, but this alone cannot be regarded as being a decisive, in and of itself, a decisive factor in providing and proving the unjustified nature of the application. And why is this the case? Well, this is the case because a different conclusion So if we would interpret it differently, well, this would discourage the patent holder from making use of these measures that are actually provided in Article 9. And this would thus run counter to the objective of the directive, which is, of course, ensuring a high level of protection of intellectual property. Now, lastly, the court decides, according to Article 3.2, the measures, the procedures, and the remedies that, well, they are to be applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide for safeguards against abuse. So the member states, and of course, in that way as well, the national courts, are to offer guarantees that the measures and procedures referred to in this Article 9 are not abused. And therefore, the courts are to determine whether the applicant has or has not abused the measure laid down in Article 9.7. And in doing so, the court must take into account, take due account of all the objective circumstances of the case, including the conduct of the parties. And this brings us to the next case that Kirian will guide you through.
Thank you, Sofie. That was very clear, and that gives us, I think, the proper understanding to look at this recent decision of the CGU in Milan versus Gilead, which is important because, of course, the CGU interprets the Article 9.7 and 7.4 of the Enforcement Directive, and the CGU's interpretation will then be binding on the national judicial authorities. And as Sofie already indicated, we have been told by the CGU already how it looks at a system which is more akin to fault liability, which it considers to be in line with the Enforcement Directive. And on the other hand, states in a couple of paragraphs that a strict liability regime as such would not be reconcilable with the Enforcement Directive. Now, in Milan versus Gilead, the factual background is very similar. There was a PI grant, and eventually the Supreme Court had revoked the PI. So during that time, the Milan had been provisionally injuncted, and eventually the SPC was held invalid. So it's similar to Bayer versus Gideon Richter and Exceltis, where also these parties had been injuncted, but later the patent right had been invalid. Held invalid. And under Finnish law, however, the situation, the liability regime is different from that under Hungarian law. Under Finnish law, in paragraph 11 of the chapter 7 of the Code of Judicial Procedure, which implements Article 9.7 of the Enforcement Directive, there is a strict liability regime if you enforce a PI. That liability, that strict liability may, however, under the same system be reduced if the damages claiming party, the defendant, has enabled the loss to occur or failed to take reasonable measures to avoid or mitigate the loss. So it starts from a strict liability regime where also the objective circumstances, the conduct of the defendant in particular, are taken into account to mitigate the amount of damages. So it's different from the Hungarian law, which also allowed to take into account the conduct of both parties, but starting from a system which is more akin to fault liability. A number of questions were referred to the CGU, and these questions actually already show, which I think was also the expectation of the majority in legal doctrine, but it shows that perhaps also the court expected a strict liability regime not to comply with Article 9.7 of the Enforcement Directive. But eventually the court only answered this first question because, as we will see, the court actually concluded that a strict liability regime under particular circumstances can be in line with the Enforcement Directive. As I said, we thought the answer would simply be no. It's not reconcilable, strict liability, with Article 9.7, a liability regime where you don't need to prove a fault by the IP holder, but where the provisional injunction as such and a later revoked right, IP right, would automatically lead to liability. Well, in our view, that was not what the enforcement directive said following the Bayer decision and this slide, which Sofie has discussed before. The fact that the provisional measures have been repealed or any other of the circumstances under Article 9.7 or 7.4 may constitute one of the conditions necessary. So it's what you need at least to trigger this provision, but you need more because in itself it cannot be regarded as a decisive factor in proving the unjustified nature. And that is, I think, why the decision of the CGU came quite as a surprise. Because the CGU said national legislation, such as the Finnish law in this particular case, may provide and will be in compliance with Article 9.7 of the Enforcement Directive if it provides for a mechanism that is based on a system of strict liability, where the court is entitled to adjust the amount of damages according to the circumstances of the case, including whether the defendant has played a part in the occurrence of the injury. Given this, at first sight, conflicting decisions, it's important to look into the motivation of the CGU's decision in Meyer versus Gilead. And that's also why it was important that we looked into the motivation of the Bayer versus Gideon Richter decision before. In my view, I don't think if we overlap the entire motivation of the both decisions, that we come to reconcilability on all points, but we could come to a conclusion which reconciles both decisions. And therefore, the motivation will be important. Another note that I want to make as part of this presentation, which we've not written down, however, is the fact that the Milan versus Gilead decision was decided by 5 justices of the CGU, who were different from the 5 justices having decided the Bayer versus Gideon Richter decision. So let's look into the motivation of the CGU's decision, Milan versus Gilead. We see that the court considers that the EU legislator chose to provide for minimum harmonization concerning IP enforcement. And in that regard, it also referred back to Article 57 of the TRIPS agreement, which, by the way, the court had also done in the Bayer versus Gideon Richter decision, as we saw before. And under TRIPS, it's explicitly stated that members are free to determine the appropriate implementation of the provisions of the TRIPS agreement. So the court concludes, given that the EU legislator chose for a minimum harmonization and that Article 9.7 transposes the TRIPS Article 57, where members are also free to determine appropriate implementation, it follows that Article 9.7 lays down a minimum standard concerning the enforcement of IP rights and leaves leeway to the member states to opt either for a strict liability regime or a fault-based liability regime. I think in this respect, we also saw before that the CGU decided in the Bayer decision that the concept of appropriate compensation should be given an independent and uniform interpretation. This is one of the points where I think both decisions come to a slightly different conclusion. Because yes, there may be minimum harmonization, but on the other hand, the liability regime, which is provided for by the enforcement directive, under the CGU Bayer decision, you would conclude that it should be one uniform concept, one uniform liability regime. Now, the Milan versus Gilead decision tries to reconcile this in the next paragraphs, where it actually discusses the Bayer versus Gideon Richter decision. In my view, that also shows that the CGU quite well understood that its earlier decision in Bayer versus Gideon Richter could perhaps be considered at odds with its decision in Milan versus Gilead. Now, the CGU stated that a fault liability regime in Bayer versus Gideon Richter, that a fault liability regime is compatible only if the court can take into account all the circumstances of the case. That's what the CGU reminds us here. So it does not state that Article 9.7 only applies in the event of a fault. And on the other hand, the fact that the conditions under Article 9.7 are satisfied does not mean that the courts would then be obliged to order compensation without looking into any further requirements. And on the basis of these arguments, it states, also building on its earlier conclusion on it can choose, member states can choose between fault liability and objective liability or strict liability. It states that the courts must be able to take into account all the circumstances of the case. That was indeed the case already in Bayer versus Kirian Richter in respect of the fault liability regime, including the conduct of the parties. But the court considers that a strict liability regime, where you can also take into account the conduct of the parties, would therefore also comply with Article 9.7 and would be sufficiently uniform in the EU jurisdictions. After having discussed this, it does turn, however, into a comparison with Article 3 of the Enforcement Directive, as the CGU had also done in Bayer versus Kirian Richter. And it refers back to the wording. It should be equitable, it should be proportionate to the system, it should not create a barrier to legitimate trade, and it should be dissuasive of IP infringement. Now, the court in Milan versus Gilead states that the combination of the system of provisional measures on the one hand and a strict liability regime in case of revoked provisional measures, a later declared invalid IP right, the combination of that system should comply with Article 3 Enforcement Directive. In other words, you cannot look at the strict liability regime without looking at the system of enforcement of provisional measures. And in this system at hand, the court considers, as we discussed before, it's a strict liability regime with the nuance that the amount can be compensated or that can be reduced if the defendant has acted in a way that it did not take reasonable measures to avoid or mitigate the injury. Now, does this particular system comply with the above requirements? Equitable, proportionate, no creation of barriers to legitimate trade, and dissuasive. Well, the court first looks at proportionate and equitable, the first two conditions. And it says, well, the system is actually aimed under the Enforcement Directive at providing a balance between a high level of IP protection on the one hand, but also ensuring that the rights and freedoms of defendants are respected on the other hand. So it says, on the one hand, in terms of high level of IP protection, you have measures to prevent an imminent infringement under Article 7.1 and 9.1. CISI and CISI-like measures to preserve or obtain evidence, and provisional measures. On the other hand, you also have measures enabling compensation of the defendant if there was no infringement or threat of infringement under Article 7.4 and 9.7. That's where the balance comes from. So if you have a strict liability regime, such as in this particular case, and it refers a number of times back to the particular strict liability regime under Finnish law, the court concludes that the fact that the defendant does not have to demonstrate a fault by the applicant is a counterweight to the fact that the applicant can obtain PI measures without final evidence, final conclusions on infringement and or the validity of the patent. And in this particular case, the court may further take into account all the objective circumstances to the case, including the defendant's conduct, and potentially adjust the amount of damages. So that ensures that a balance is preserved. Second question, is there then a barrier to legitimate trade or not? And the court says no. There is no barrier to legitimate trade in case of a strict liability regime, such as in the present case. Again, this reference to the present particular situation, because if the IP right is declared invalid retroactively, the acts of the defendant were part of legitimate trade. The defendant did not actually illegitimately act when trying to enter the market, because at that point in time there was actually only an invalid IP right. And finally, a strict liability regime does not call into question the dissuasive nature of the system of provisional measures. Why? Because the court actually says the defendant will be able to obtain damages for the injury caused by these measures, but the defendant will not be able to obtain damages which exceed what was caused by these measures. So it's a counterbalance, but it's no, it has no effect where it undermines actually where IP holders will refrain from trying to obtain provisional measures, because it's just putting the defendant back into its original situation, also taking into account his or her conduct. Now, some conclusions, and I've listed 3 on the CGU decisions, because it's a lot to, I think, digest also. It's quite technical decisions and they have some conflict. But I think we can come to 3 conclusions. First of all, the member states can choose between either a fault liability regime or a strict liability regime. Under Bayer versus Kirian Richter, a lot of people thought it was a fault liability regime and it should be a fault liability regime. But after Milan versus Gilead, it can be both. That's what the court states explicitly. Member states may opt, as the case may be, for a strict liability regime or a fault liability regime. There's no conclusion whatsoever, in my opinion, in our opinion, that member states are now obliged to implement a strict liability regime, or that Article 9.7 and the implementation thereof under Belgian or national law should be interpreted as a strict liability regime. The second conclusion is whatever regime a country chooses, the court should be able to take into account all the circumstances of the case. Again, this is stated explicitly by the CGU in Milan versus Gilead. So what does that mean in practice? If you have a fault-based liability regime, it's important that there is this counterbalance where you can also look at the applicant's conduct. For instance, has he or she abused his or her rights? That was also stated explicitly in the Bayer versus Kirian Richter decision. If you have a strict liability regime, which is then in favor of the defendant, you also need to be able to look at the defendant's conduct. Has he or she aggravated the damage that resulted from this enforcement of the IP right? And then finally, the liability regime that is imposed should be in balance with the provisional measures regime. That's a third overall conclusion that we can draw from the CGU decisions. That brings me to the Belgian story. And under Belgian law, in Belgium, there's always been a distinction between 2 very different systems, and that results from the general liability rules. We have Article 1382 of the old Civil Code, which is actually the basis for any liability, fault liability, tort that has resulted from one's fault. So it's fault liability. But we also have a different provision, Article 1398 of the Judicial Code. And this actually considers the situation where you have provisionally enforced a judgment that was provided or that was rendered at the level of first instance, and then at the level of appeal, it's overturned. Because the enforcement of your first instance decision, judgment, will be at the risk of the party enforcing it. And because it's at the risk of the party enforcing it, it leads to strict liability for that party having enforced it. If, in other words, a first instance decision, PI decision, is overturned and later revoked then by the Court of Appeal, still in PI proceedings, you will be liable strictly, objectively for the damage caused by enforcing that first instance PI decision, versus a fault liability in all other cases. And that's what we indeed saw before the enforcement directive in respect of the enforcement of IP rights. There was a strict liability when enforcing a subsequently overturned decision, a CZ decision, a PI decision was confirmed by the Supreme Court. And on the other hand, there was fault liability in all other cases. For instance, if you had obtained a PI that was later invalidated, or a PI where on the basis of an IP right that was later invalidated, or if you had obtained a CZ, even in a final manner, confirmed by the Court of Appeal, in a case or on the basis of an IP right that was later invalidated. Again, this was also confirmed by the Supreme Court, but in various decisions as well by the Brussels Court of Appeal. And then the enforcement directive enters into force and we get new decisions. Again, it's still strict liability when enforcing a subsequently overturned decision. That's the first situation under Article 7.4 and 9.7 of the Enforcement Directive. And the Supreme Court confirmed this in 2018. There is strict liability if your PI or CISI is later overturned in appeal or in third-party opposition proceedings. The other situation is in case of a negative decision on the merits. If there is subsequently found to be no threat of infringement, then you have fault liability. That's the third situation under Article 9.7 and 7.4. That's been confirmed by the Brussels Court of Appeal recently, 2 years ago. And it's in line with the earlier decisions, which I showed on the previous slide of the Supreme Court and the Brussels Court of Appeal. But there is a conflicting decision by the Ghent Court of Appeal of 2014, which considered that there was strict liability for CISI measures. I'll discuss that decision briefly also because it's important to try to come to a conclusion on Belgian law. I want to note, and we'll discuss that also later, the Brussels Court of Appeal decision was in a case based on patent rights, and the Ghent Court of Appeal decision was in a case based on database rights. And the Ghent Court of Appeal was in the CISI, and the Brussels Court of Appeal was in respect of provisional injunction, provisional measures. The question, what in case of lapse due to an act or omission by the applicant? So what are we thinking of here, at least in my opinion, is of course, if you obtain a CISI or a PI, you need to follow up under the Enforcement Directive within 20 working days or 31 calendar days with your main action. If you don't do that, your CISI or your PI will lapse due to your omission as the applicant not having filed the main action. In such particular case, there is no basis under Article 1398 of the Judicial Code in Belgium to come to the conclusion that there is a strict liability, because it's not a provisional enforcement of a first decision that was later overturned in appeal or in third-party opposition. It's a case where the general rules under Article 1382 of the old Civil Code will come into play, and that's why I think that it is, and most people think that it is a case of fault liability. Of course, the fact that you do not follow up with proceedings on the merits can, of course, qualify in itself as a fault, but that will be for the defendant to prove, because on the other hand, there may be very valuable reasons why you do not follow up with an infringement action. Now, let us look into the Brussels Court of Appeal decision of 2022, because it's the most recent decision by one of the highest courts in Belgium, and in any event, in patent cases, the exclusively competent Court of Appeal in Belgium. And in this case, as I said before, there was a European patent. A provisional injunction was granted by the Brussels Court of Appeal itself at the time that the European patent had been declared invalid by the opposition division, and that national tiers had been invalidated by the Dutch Court of First Instance and the UK Court of Appeal. Now, this provisional injunction, still the patent was considered prima facie valid, and the provisional injunction, the PI, was confirmed by the Supreme Court. The European patent was later finally revoked in a final manner by the TBA, and Mylan claimed damages. Now, the Brussels Court of Appeal stated and confirmed the earlier case law of the Brussels Court of Appeal of the Belgian courts, and also in line with Bayer versus Gedeon Richter, that there is no strict liability in this particular case. It said, just like the court did in Bayer versus the CGU did in Bayer versus Gedeon Richter, a different conclusion would have the effect of discouraging the IP holder from enforcing its rights and would run counter to this directive's objective of ensuring a high level of IP protection. Essential, the Court of Appeal considered is the fact whether the IP right holder abused the measures and procedures provided for in the Enforcement Directive, and thereby considering all the objective circumstances of the case. So it used also the wording of the Bayer versus Gedeon Richter decision, which stated that such particular situation would be in line with the Enforcement Directive. So the court said, we revert to Article 1382 of the Old Civil Code, and the Belgian law is therefore in compliance with the directive, in line with the CGU's decision in Bayer versus Kirian Richter. It then looked into whether or not there was indeed a fault, and I think it's important to discuss this briefly because the court considers first, has Novartis, the patentee, did it commit a fault? If not, did it abuse its rights? And it thereby also implemented further the decision of the CGU in Bayer versus Kirian Richter. And it stated no, Novartis did not commit a fault because at the time it was actually granted a PI. It was assessed on the basis of the relevant rules, prima facie validity, prima facie infringement, by the Brussels Court of Appeal, whether a PI was warranted, and the Brussels Court of Appeal had concluded yes. And the Supreme Court had confirmed this PI. So that's already a first reason. Second reason, the retroactive effect of the invalidation is not sufficient, because otherwise, if the mere retroactive effect of a nullity decision of whatever right, the patent right in this particular case, would lead to a fault, then you would actually have a case of strict liability. And that is not what the enforcement directive aims for. And finally, Mylan, the defendant, did not prove that Novartis knew or should have known that the patent was invalid, and it thereby referred to a number of points. The general statistics, which Mylan had advocated on revocation rates, are not sufficient. The fact that auxiliary requests, which are in essence auxiliary, have been filed, are not sufficient. The fact that there is an opposition decision which is negative is not necessarily sufficient, can be one of the elements, and foreign negative decisions on the merits are not necessarily sufficient, can be one of the elements, but in this case they were not sufficient and Novartis did not commit a fault. Novartis did also not abuse its rights because it actually enforced its rights, exercised its rights in a manner that was in line with normal exercise by a prudent and foresighted person. What about the Ghent Court of Appeal's decision? Because you could conclude, yes, there is fault liability regime in Belgium in case of a later revoked IP right. But on the other hand, you still have that Ghent Court of Appeal decision. As I said before, it's based on database rights. It was a saisie, and on the merits there was held that there were actually no database rights. I think, and that's my opinion, which I think will be shared by others, but some will contradict, I'm sure of, the conclusion of strict liability is, in my view, likely incorrect. Why? First of all, in this decision, the Ghent Court of Appeal argues that Article 9.7 and the implementing Belgian provision requires objective liability. Now, we've seen already that that is not the case because the CGU has stated, after, of course, the Ghent Court of Appeal this decision, that member states are free to choose between fault liability and strict liability, but this does not impose a strict liability regime, which was nonetheless the conclusion of the Ghent Court of Appeal. That's already, for me, the main reason why the Ghent Court of Appeal's decision is probably incorrect. Secondly, the strict liability regime imposed by the Ghent Court of Appeal is actually one which does not take into account other circumstances. It's just the fact that you've been granted the saisie on the basis of database rights, which were later contradicted on the merits, no database rights. That in itself is sufficient to provide damages. So I think that also is probably not in line with the CGU's decision in both Bayer and Mylan. And then finally, I think it's also in contrast with the Brussels Court of Appeal's decision of 2022, which already was able to take into account Bayer versus Kirian Richter CGU's decision, but also with earlier case law of the Belgian courts, which I showed you before, the Supreme Court, the Brussels Court of Appeal, and other decisions which had confirmed prior to the enforcement directive, the entry into force of the enforcement directive, the implementation on the Belgian law of the enforcement directive, but which had confirmed also that there was fault liability regime. And now that we know that the enforcement directive does not preclude fault liability regime, such as that under Article 1382 of the old Civil Code, I think the conclusion of the Ghent Court of Appeal is thus wrong. So my conclusions on Belgian law, Belgian case law, would be, in Belgium, you have a strict liability regime in case of an overturned PI. So if you have a first instance decision, a PI, provisional injunction, or a CISI that is later overturned in appeal or in third-party opposition proceedings, you will be held liable as the IP right holder if the defendant, of course, claims damages. That system is in line with the enforcement directive because Milan versus Gilead has stated this. And I think there should be an important layer following Milan versus Gilead on this system, and that is the fact that you can also take into account the objective circumstances of the case, including the conduct of the defendant, the one that was imposed PI on, the one that was the subject of a saisie contrefaçon. So the strict liability regime as it existed with a slight correction is in line with the enforcement directive. Secondly, the fault liability regime also would apply, on the other hand, to a case where the PI or the saisie lapses due to an act or omission of the IP right holder. That again is in line with the enforcement directive. See Bayer versus Gedeon Richter. In this particular case, as I said before, it would perhaps be more easy to qualify the fact that later proceedings on the merits, for instance, were not filed, and as a result of that, the first preliminary measures, provisional measures, PI, saisie, lapsed. That would be perhaps more easy to qualify as a fault. And then finally, when an IP right is later invalidated or non-infringed, and that was the particular subject of the Bayer versus Gedeon Richter decision and of the Milan versus Gilead decision, if in such case a fault liability regime applies, which it does in Belgium, as I've discussed before, at least in any event under the case law of the Brussels courts, and perhaps also by extension under the case law of the other courts in Belgium, that fault liability regime is in line with the enforcement directive. And it will be important for a defendant to prove either that the IP right holder committed a fault or that he or she abused her or his rights when enforcing these rights. So a last conclusion, perhaps overall conclusion, and that's the conclusion of this seminar. When the CJU gives you inexplainable decisions, perhaps conflicting decisions, try to make a webinar explaining them. And that's what we've tried to do for you today. So we thank you for subscribing to this webinar, to all our other webinars, for listening in, for your attention. I thank Sofie for her presentation on the enforcement directive and Bayer versus Gedeon Richter, and for helping prepare this entire presentation. I thank Guillaume from the technical perspective also for his support. If there are any further questions, I see we still have about 12 minutes, which is sufficient to answer some questions you may or may not have. And if not, I wish you a very happy Easter weekend already. Thank you very much.